everybody. It's a great pleasure to be with you on this wonderful afternoon. But what I'm going to talk about is something very general, something which is quite fundamental in approach, unlike the detailed presentation on the laws which were made by my predecessor. Now, I'm a member of the tribunal. I hold this office, and therefore I have to give some clarification before I speak. First of all, anything which I state is not necessarily in my view. It doesn't affect my employer or for that purpose anyone. And I'm going to touch only with the judicial doctrine of substance over form. And I do not propose to deal with the GAR or with the role of judges in implementing this doctrine, on which you have separate sessions. Now, if we really look at what is doctrine of substance over form, it's a judicial creation. Now you have it codified, and you have as precisely codified with as much of fine details as we just heard in US. But essentially it's a judicial creation, and it is invoked in the cases in which taxpayer has conducted a scheme of transactional relationships in documents with a view of tax advantages that flow from tax reporting it in that manner, rather than of the substance of the arrangement. The economic reality is thus hidden, and transaction exists in form only. That is what you call classical approach to the doctrine of substance over form. The way the relationships are created, the way the documents are formed, they show things which are advantages from the point of view of tax reporting, which flow of tax advantages which flow from tax reporting as such. However, the manner in which it is being implemented in India, in judicial doctrines, I would say, particularly in the recent years, and before that, of course, I have to clarify that this doctrine thus allows tax authorities to ignore the legal form of an arrangement and to look at its actual substance so as to prevent the artificial structures from being used for tax avoidance purposes. The entire theory of doctrine of substance over form is for the purpose of avoiding this kind of a use of artificial structures for tax avoidance purposes. Now, as I said, in its pure form, when on the basis of evaluation of evidence and analysis of facts, judicial authorities find that tax motivation for structuring the transaction outweighs business purpose or profit objective, it is held that taxpayers' effort or form does not reflect the substance of economic transactions, and on that basis, tax benefits are declined. Therefore, the doctrine of substance over form in its pure approach, all it says is what are the motivations in structuring the transactions in a particular manner. And in situations where tax motivations outweigh everything else, that is business objective or profit objective, then judicial authorities come to a conclusion that the form which is shown, it does not reflect the substance, and accordingly, what flows from that is that intended tax benefits, which were available based on the tax reporting as such, are declined. However, when we look at the recent Indian decisions, you find that it's a slight diversion from the classical approach to this, and this says that substance prevails over form only when the form has no commercial justification. And that's a big paradigm shift, because one thing is tax motivation outweighing the business consideration. And second thing is whether you have some business consideration at all or not. The way things stand today, and as I say so, I depend on the decisions which have been taken in the recent years, and of course by the highest courts. These are the cases where substance would prevail only when there is no commercial justification whatsoever and the transaction is completely tax driven. For example, in the last decision which has been referred to a lot in Vodafone also, what they mention about is the commercial justification and the existence of commercial justification. But to my mind, if I approach this doctrine in its pure format, my question will be far more fundamental. My question would be in that situation, whether the benefits that I derive on tax and whether therefore the motivation, tax motivation I have, does it outweigh the business purpose? But that is not the case as far as the present Indian situation is concerned. Now, the question is, do we really need doctrine